arrest, bail, and going to court. It's not just young people who can be confused about their rights with police. It can be tricky for youth workers who call us about situations like this. Police come into a youth service looking for 17-year-old Matthew. Matthew is a client of the youth service, and the police say they're suspecting him of being involved in a car theft last Friday. The police ask the service for Matthew's address and his phone number. The service has information about where Matthew was on Friday. They know he wasn't at school. The service also knows his phone number and that he's staying with a friend. Does the service have to give the police Matthew's phone number and address just because they ask for it? If police reasonably believe that you have information that could assist them with the investigation of a serious offence, then you have to give them your name and address. Besides your name and address, you only have to hand over information if police show you a subpoena or a warrant. A subpoena is a court order which can either demand someone attends at court or demand certain documents be produced to court. A warrant is also a document issued by a court. It can be a search warrant, which allows police to search the premises, or it can be an arrest warrant, which allows police to enter and search a place in order to arrest someone. If police don't have a warrant or a subpoena, then you don't have to give them any other information. You also owe Matthew a duty to protect his privacy and confidentiality. If you know or suspect Matthew has committed a crime, you do not have an obligation to report this to police as long as you're not assisting Matthew to commit a crime. You must be careful, though, not to hinder or obstruct police as they perform their duties, or to hide Matthew or intentionally help him evade arrest, as that could lead you to being charged with criminal offences. What happens if the police find Matthew, arrest him, and take him in for interview? By law, when Victoria Police interview a young person who is under the age of 18, there must be a parent, guardian, or independent adult present during the interview. Where a parent or a guardian is not available, the police can contact the Youth Referral and Independent Persons Program for a trained volunteer who can stand in as the independent person during the interview. As a youth worker, you could also act as the independent person for a young person in that police interview. So what is the role of the independent person in a police interview? As an independent person, your role is to make sure that the young person understands and can assert their rights. For example, the right to speak to a lawyer, the right to contact a friend or relative, and the right to silence, that is, to give a no-comment record of interview. An independent person must also sit in on the police interview and make sure that the young person understands the questions that the police are putting to them, and to make sure that the young person is not being harassed or intimidated by police. The independent person is also there to provide support, like arranging accommodation for the young person once they leave the station if that's required. If a young person is at the police station and you've been asked to be their independent person, you should try and get to the police station as soon as possible. You should check with police if the young person is, in fact, under arrest, and if so, what for. You should ask to speak to the young person in private. Check with the young person if they know why they've been arrested, if they've sought legal advice, and if they understand their rights, or if they need special assistance. For example, if the young person is injured, withdrawing from drugs, or if they have an illness or disability, it's important to liaise with police and make sure that the young person gets any assistance that they require. Do the police have the power to take Matthew's fingerprints or his photo? And what about forensic samples and police lineups? Because he's over the age of 15, police have the power to take Matthew's fingerprints if they suspect he's committed a serious offence, like theft. If he refuses, the police can use reasonable force to take Matthew's fingerprints. If Matthew was aged 10 to 14 years old, then he, or his parent or guardian, could refuse to give his prints, and police would need to get a court order. Police may ask Matthew to go in an identification lineup, but he is allowed to refuse. It's important that he gets advice in making that decision. Matthew also has the right to refuse to be photographed by police. Because Matthew is under 18 years old, Police cannot take forensic samples like blood or saliva from him, even if he consents. So, if they want these, the police would need to get a children's court order. If Matthew was over 18, he could consent to a forensic procedure, but he could also refuse, and in that case, police would need to get a court order as well. So what will happen to Matthew after the police interview? Well, there are a few possibilities. One is that they could release Matthew without charge if they don't have enough evidence. The police could also release Matthew with a caution instead of charging him. If the police do charge Matthew, they could release him on summons to appear at court on a later date, or they could release him on bail. Bail is a promise that you will attend at court on a particular date, and it might have special conditions like living at a certain address or even a curfew. Police may hold Matthew in custody until the next court sitting if they think he's an unacceptable risk of reoffending, or if he was already on bail for another offence. Matthew can either contact his lawyer to help him with a bail application, or there will be a duty lawyer available at court to assist him on the day. If Matthew has to go to court, what can you tell him to expect when he gets there? You should make sure that Matthew knows about court etiquette. He doesn't have to wear a suit, but it is important to dress neatly and not to wear things like shorts, thongs or singlets. He can't wear a hat or sunglasses on his head inside the court, and remind him to turn off his mobile phone. You should also warn him that things can take a long time at court, so he might need to be patient. As a youth worker, how can you help Matthew if he has to go to court? You can make sure that Matthew remembers the time, the date, and the location of his court hearing. If Matthew misses his court date, then the court could issue a warrant for his arrest. If he was on bail, he could also face further charges. To find out Matthew's court details, you can check the Magistrates Court website or phone the Children's Court. You should also make sure that Matthew sees a lawyer for advice. He can contact Youth Law or Victoria Legal Aid for free legal information and advice. If Matthew can't get an appointment with a lawyer before his court date, make sure he knows about the Duty Lawyer Service, which is available at the Children's Court for young people facing charges who don't yet have their own lawyer. What about preparing a support letter for Matthew at court? Support letters can greatly assist a young person in their court hearings. Support letters are voluntary, and you should only write one if you think it will say something supportive of the young person. You should address the letter to the presiding magistrate or the presiding judge. Explain your background, your role in your organisation, how long you have known the young person. You should mention that you know why the young person is in court. And tell the magistrate what you know about the young person's family history, their schooling, challenges and achievements, and what you know of the circumstances leading up to the offence if you think it would be helpful to the young person in court. To recap, we hope that this session has given you an understanding of the powers of police and other authority figures when dealing with young people, the rights of young people when dealing with police and those authority figures, the rights of young people under arrest, and how you can support a young person through the process of arrest, bail, and appearing at court. If you would like more information, please check out Youth Law's website at www.youthlaw.asn.au. You can also contact Youth Law for more information or to refer a young person for legal advice. You can do this via email to info@youthlaw.asn.au or by phoning 03 9611 2412 during business hours. Youth Law would like to thank the Victoria Law Foundation for making this video series possible. Thanks and good luck.